Do you know what decriminalization of marijuana in Virginia really means? Can the police still search your car for the odor of marijuana? This is your ultimate guide to Virginia's marijuana decriminalization and everything that you need to know, including frequently asked questions. Number one, marijuana is still illegal in Virginia. It's still considered contraband. All the legislature does is on July 1st, 2020, marijuana is no longer punished for simple possession as an actual misdemeanor. The penalty is a civil penalty. We'll get to that. It's still illegal though, so you got to be aware and keep that in mind. Marijuana is still illegal in Virginia. Number two, the police can still search your vehicle for the odor of marijuana. This is where I think we're going to see a lot of trouble that people receive from marijuana laws. Is the police officer going to pull you over for something and come up to the car and say, hey, I smell the odor of marijuana, step out so I can search. That's still allowed because it's still contraband. And frankly, they may be suspecting you of distributing marijuana or having something other than marijuana in the car. Number three, if you're found guilty of the simple possession of marijuana in Virginia for cases that occur after July 1st, the punishment is simply a $25 civil penalty. So that is true. There's no court cost, it's 25 bucks. You could literally sit on the courthouse bench out front, smoking a joint, get charged with marijuana and pay a $25 civil penalty every day of the week. Number four, if you're found guilty for possession of marijuana after July 1st of this year, they do not suspend your driver's license. Used to it was 6 months. Now there is no license suspension in Virginia for simple possession of marijuana. Number five, you still cannot drive under the influence of marijuana or alcohol or anything else. So this is where I think a lot of people are frankly going to get themselves into trouble, is having a joint or two, thinking it's okay, it's no big deal if I get caught, and driving to work, officer sees you swerve or something, pulls you over, and the rest goes downhill from there, and you end up facing what we call is a DUID for driving under the influence of drugs. That is still illegal, and frankly I think we're going to see a lot of driving under the influence of marijuana charges now that people are going to think that marijuana is kind of free reign. So do not drive under the influence of marijuana. Number six, the police will confiscate your marijuana and any paraphernalia or equipment you have with it. It's still contraband, like I mentioned earlier. So if you have marijuana, you're driving down the road, someone asks me, will the police take my marijuana? Yes, they will take your marijuana. It's still contraband, so I would not carry it around in your vehicle. Number seven, another question I received is, can the police ask where I got my marijuana? Well, of course, they can ask you anything that they want to ask you. The question is, are you going to answer? My general rule is, never answer police questions, period. The only proper response to a police question when you're suspected of a crime is, I invoke my right to remain silent, and be silent. Number eight, it's still a crime to distribute marijuana. So if you're caught distributing marijuana in Virginia, even though simple possession is a civil penalty, you could still be charged with a crime. The level of the crime depends upon how much marijuana you're alleged to have when they catch you. The possession of marijuana with intent to distribute of not more than 1 ounce is just a misdemeanor after July 1st. Anything over that would be charged as a felony. There's also a presumption in the code that possession of no more than 1 ounce of marijuana, we assume that you're just possessing it, you're not actually trying to distribute it. So the Commonwealth would have to overcome that presumption if they want to charge you with possession with intent to distribute. Ways they might do that is if you have baggies, scales, some evidence that you're actually distributing, like text messages on your phone, or if you admit to something. So be careful. Obviously, if you have marijuana at all, you shouldn't, because it's against the law, but you obviously want to make sure to protect yourself from any claim that you might be distributing the marijuana, because that is a crime. It could be a misdemeanor or a felony depending upon the amount. Number nine, marijuana arrests and convictions are not open for public inspection after July 1st. What does that exactly mean? It's anyone's guess how this is going to play out. Basically, the law in Virginia is changing on July 1st. And except for certain categories of jobs, primarily law enforcement applications or actual prosecution in court, marijuana arrests and convictions are going to sort of be sealed on your record. The statute doesn't use the word sealed, it says not open for public inspection, which to me says that if someone pulls your actual criminal record, the marijuana arrest or conviction should not be on your criminal record, unless it's being pulled by a prosecutor, for a law enforcement agency if they're looking to hire you, and for about 10 different other reasons. However, your average employer or educational institution should not see a marijuana conviction or arrest on your record. Number 10, the key thing to then remember though is the police can still see it on your record. So when the police pull you over, they run a record to see if you've ever been in trouble before, they're going to still see that you've got a history of marijuana. And so they may still have some reason to suspect you of having something today and hassle you on the side of the road. The same thing goes for prosecutors. If you're in trouble in court, they pull your record, they'll still see the past marijuana offenses that are on your record. So it's not sealed, it's not expunged, it's exempt from public disclosure for certain purposes, which is your average employment application essentially. Number 11, if an employer or educational institution asks a question about prior marijuana arrests or convictions, they actually can be charged with a Class 1 misdemeanor. So this is something to be aware of if you're an employer or have anything to do with hiring, is you cannot ask about marijuana arrests or convictions after July 1st. They're exempt from public disclosure, as we mentioned, and it's actually a misdemeanor for an application or an interview process to ask questions about it, except for those specific exemptions. Number 12, keep in mind that employers may still see marijuana convictions if they were to look you up in, let's say, the court's online database. This is where this whole record thing is kind of a mess. We've tried to make it essentially where it's going to be hidden from some people, but some people can still see it. But if anybody just searches your name on the court's public website, they can find that you had a past marijuana arrest and conviction in all sorts of different courts. It's there for the public to see depending upon where they look. So it may not be completely gone from a background check process, but employers certainly can't ask direct questions about it. And finally, number 13, possession of oil is no longer a felony. Used to, if you had oil that had a certain concentration of THC, it could be charged as a felony, and a lot of people were getting into some trouble for that. After July 1st, all of it is just simply called marijuana. The next law you need to learn about is the new handheld cell phone ban that goes into effect in Virginia soon. Check out my next video about how to get ready for that.